And with that, we're going to get started. If you could please, we're going to actually start by introducing our below market housing team and my colleague Jonathan Irwin Frank from City Attorney's Office. So could we start with Richard? Richard, could you introduce yourself? Maybe he hasn't joined yet.
Yeah, it looks like he's still listed as not having joined yet.
All right, Jonathan, could you introduce yourself?
Sure, I'll turn on my camera here. Hi, everyone. Jonathan Irwin Frank, Deputy City Attorney. I work closely with the Housing Division and the Below Market Housing Program. Some of you may have interacted with me before. Typically, I get involved when something kind of gets escalated, to the point where legal advice is needed.
Thank you, Jonathan. Brittany?
Hi, I'm Brittany Aguirre. I'm a policy and performance analyst for BMH. So if you ever need help with referrals or any questions with below market housing, I'm here.
Thank you, Brittany. Richard?
Hi, everyone. Richard Diaz, Senior Administrative Analyst with the City's Housing Division. I work with Nick and Brittany on the BMH program, among some other things. Glad to be here.
Thank you, Richard. With that, I am actually going to go ahead and share my screen again, and we are going to jump right in. Now, in the meantime, as housekeeping, if any of the participants have questions, you are welcome to raise your hand in the chat. That is one of the options, I believe. If not, you are welcome to type a question into the chat. If I don't see it right away, then if Brittany, if you could flag it for me, and if that's still to, and regardless of that, if you would prefer to just shout out your question, we can try that as well. So questions are welcome throughout the presentation. Don't be afraid to jump in. You may not be the only person with that question. So to start, for those of you who are here in attendance on behalf of property management, whether you are the owner, the property manager, or otherwise affiliated with property management, if you could do me a favor and put your building address and your name into the chat so we can keep track of who is here, I would appreciate that for housekeeping purposes. I'm going to go ahead and share my screen while you do that. Oh, I'm already sharing it. Okay. And while you introduce yourself, I'm actually going to jump into our material. And like I said, if you have questions, please do not hesitate to raise your hand, send a message, or just shout it out. Because I'm not sure if I'll see the raised hands, but try it. And if I see it, I will stop and take your question gladly. So to get started with, this is our first information session for landlords that I'm aware of for the BMH program or the below market housing program in general. So your feedback is welcome on this presentation, and I hope it will be useful to you. We're going to start by talking about what is the below market housing program, general components of it, and how it's different, but still works together with other housing programs Santa Monica has, because I think that sometimes we see confusion between below market housing, voucher programs, and rent control. So to start off with, below market housing, BMH, is also the formal name is AHPP, that's Affordable Housing Production Program. If you go online and you type in Santa Monica AHPP, you will see parts of our city website that pertain to this program and its requirements, administrative guidelines and regulations, and you can even look up Santa Monica Municipal Code pertaining to the below market housing program under its legal name AHPP. Now, AHPP is almost comparable to a master lease. So what I mean by that is typically landlords would have a building. They're trying to get a building built. In some cases, a landlord may have a building damaged by the Northridge earthquake that they were requesting they would like to rebuild a certain way. And as part of the approval process, the landlord at the time or the owner at the time agreed that a portion of the total units in the building, or in some cases, every unit in the building, is going to be rented at a level below the market rate rent. So that is almost like a 55-year master lease for the unit. And there are also, I should add, condominiums subject to this requirement. And if you are the owner of a condominium, we can talk about that as well, because it does look a little different. Having an owner, especially if the owner is living in the condominium, versus a rented condominium versus an apartment building. But for the purposes of AHPP and just talking about the program at a high level, we're going to talk about it from the perspective of an apartment building because most of the units under AHPP are units in apartment buildings. So rent control has been around for several decades in Santa Monica. So has this program, I might add. But rent control is limiting the percentage increase in the rent for as long as a tenancy holds within a controlled unit. So rent control does not apply to every building. It applies to certain buildings, and it applies for the length of the tenancy. And when the tenant vacates, the rent gets reset, and the rent can be as high as the market will support in many cases. I don't say in every case, because there are also buildings where not only is it a rent control building, it is also an AHPP building where the rent for the unit will also be controlled by our program, which is what I'm talking about.
And I'll just make a very quick note, because this is something that's still in effect right now. We have rental housing price gouging protections, which limit rent increases. That does include even after vacancy. And so I just wanted people to be aware of that.
Thank you. For those of you who have rent control specific questions about how much you can increase under rent control, I will direct you to the rent control department. It is a separate department. It is a separate program. It is also a separate part of municipal code. So we do work together because some units are subject to both. They are subject to rent control and they are subject to AHPP, but we are not the same thing. Before I proceed, do we have any questions about the difference between rent control and AHPP? Hearing no objections, I'm going to go forward. So the third program here we're talking about are vouchers. And a voucher, this could be self-explanatory for some of you, is a federally funded program from the federal government. Therefore, it's going to follow federal regulations, and then we also have our city requirements. If you have a question about a voucher participant, about voucher program regulations, again, there's a separate portion of our city website. If you type in Santa Monica Housing Authority Administrative Plan, you will have a very lengthy, very detailed 600+ page document spelling out the different processes for voucher tenancies, including income calculation requirements. Now, voucher programs do overlap with AHPP frequently. We have a lot of people who have vouchers who use their voucher in a deed-restricted program unit. And I think sometimes, again, landlords may not always be clear on which program they're talking about. I'm working today as a representative of AHPP, not voucher programs. But if you have specific program questions for voucher-related subjects, topics, and issues, if you are trying to reach a voucher staff member, you may email me, and I'll do my best effort to connect you with our voucher side staff as well. So vouchers, the voucher is basically where the federal government pays some or up to all of the rent on behalf of a low-income tenant or household. Our program is different. In our program, some cases, the tenant will be a voucher recipient, meaning the housing authority will be paying some or all of the rent. And in other cases, not the case. The tenant will pay the full amount. So the two can go together, but don't always go together and don't have to go together. So before I proceed, do we have questions on the difference between AHPP on one hand, deed restrictions, voucher programs on the other hand? Okay, hearing no objections, I'm going to proceed. I mentioned earlier that deed restrictions are a bit like a master lease, where for 55 years upon signing and notarizing the deed restriction, whatever is contained in the deed restriction is applicable to those units. Now, in some buildings, the units subject to the deed restriction change because the building might have 100 units, of which 20 are subject to a deed restriction. And the landlord may have the ability to, over time, as tenants come and go, to shift which unit in the building is subject to the deed restriction. There are other cases where that's not possible, whether it's because the deed specifically says it's this one unit, it's these 10 units, it's every unit in the building. It doesn't apply. But I just want to point that out that in any case, as a landlord, if you're in one of those buildings where some and not all of the units are subject to a deed restriction, you should be paying careful attention to which unit is deed restricted. And that's the one to which today's presentation applies. I also want to talk about the difference between the landlord role and the city staff role in administering the AHPP program. Landlords are administering the program to tenants. So as the landlord, I would encourage you to have a certain level of familiarity with basic program requirements. And that's why you're on the call today. And I want to thank you for making the time so that when tenants come to you and they have questions or something they say doesn't quite add up, you have that basic level of familiarity to explain the concepts of the program at some level. And if it's not resolvable at that level, you can come to city staff and we will also chip in and do our part and see if we can clarify things for you and the tenant. But I want to be clear that housing staff, our role is that of an auditor and an information provider, like I said, and also as an administrative rulemaker, meaning that we have the ability to adopt and develop program guidelines over time. And those are also publicly viewable online, I might add. What our role is not, we are not direct case managers. We are not in the same role as housing authority staff. So housing authority staff, for those of you who have tenants who receive a subsidy from Santa Monica Housing Authority, the tenant has a housing specialist, and the housing specialist will directly contact the tenant and say, hi, John or Jane Doe, your recertification is due July 1. It is time to turn in your documents. Send them to me, the staff. Staff member reviews it, staff member asks questions, staff member approves or disapproves a rent increase for the unit, staff member approves or disapproves continuing subsidy for the tenant based on the program requirements, the tenant's compliance or non-compliance with program requirements. And then the staff member says, okay, the new amount, Jane Doe, the tenant, you're paying $100 a month. The rest we cover. Hey, landlord, heads up, July 1st, our amount is changing to X and the tenant's amount changes to Y. That's how it works on housing authority side. But we are not the housing authority. On our program, AHPP, the landlord is going to do the income certification with the tenant directly. Housing staff like me, we are available to clear up questions, explain policy, and kind of troubleshoot. But we're not going to work with the tenant directly 99% of the time. Now, having said that, I want to introduce one more element of all of this, which is tenants still have the right to know about this program. When a tenant is signing a lease for a deed restricted unit, the tenant should know they are signing a lease for a deed restricted unit. They should know the unit has a deed restriction. They should know they will be expected to provide their income information not only before they leased up, but annually, because that's a requirement of our program in the policies available online. It gets really tricky if the tenant says they didn't know and the landlord never collected documentation showing they informed the tenant at the time of move-in. Hi, tenant, you are part of a deed restricted unit. And so you have the expectation you will comply with the deed restriction requirements and also with the AHPP program guidelines and also the tenant's own lease, right? Now, tenants can and do come to the public housing counter. We have a public counter open Monday through Thursday, 9 a.m. to 4 p.m. here at City Hall East. We're off of Olympic Boulevard. And people will come in and they'll have questions for us, like, is my unit subject to a deed restriction? What is the maximum allowable rent? Hey, city staff, here's a copy of the notice my landlord gave me. Can you confirm that the rent increase is accurate? What should my maximum rent be? And we will do our part to help them because they came to us directly. But that's a we will help them. We will explain it. We'll say, yes, the unit is deed restricted or not. Based on your notice, I can see this in the system. This is how we would calculate maximum allowable rent. And we would basically explain to them the level of information we are providing you in this training as well, because the tenant is also a participant in the program. So sometimes tenants do reach out to us by phone, by email, or in person like that. I just want you to know that that's how we interact with them when they come to us. So in the name of transparency, I want you to understand that. Tenants also have the right to view a copy of the deed restriction. So if they ask, we can provide that as well. And if the tenant has previously supplied information for their annual reporting requirement, like, hi, I'm John or Jane Doe. I've lived in my unit 5 years. Can you show me what you collected or the landlord collected on my behalf for that unit in the last 5 years? We can also provide that to the tenant, assuming it's the same person in the household.
Hey Nick, there's a question in the chat. Is the
Go.
recertification due in their lease renewal date or due on a certain date?
It is not necessarily time to lease renewal. Thank you, Brittany, and also thank you to the person asking. You have to submit one annual report per deed restricted unit per year. You can do so before the city deadline. You should not be doing so afterwards. So if most of you who are in here probably got a notice from me in the mail or email asking you to submit annual reports no later than May 15th, 2025. You, in future years, are welcome to submit those reports early in the year before I formally notify you. But if I set a deadline for you of May 15th, 2025, then it needs to be done by May 15th, 2025 for each deed restricted unit in the building. Now, if the lease renewal is also before May 15th, 2025, that works out great for all parties involved. But if not, you still need to turn in your annual reporting by the deadline specified in the notices we send you. On a related note, we are available to you as owners, managers, owner representatives. We are available to be useful. Please reach out to us with questions or clarification, but please do not pass on our direct staff emails to tenants without asking and getting a permission from us in advance, because again, we are not case managers to the tenants. We are liaisons to you as the owner and owner representatives. It is the owner's responsibility to be familiar with our AHPP policies. If you do not understand something, please ask for clarification. If you do not understand how to do an annual recert, please ask us before the deadline and make a good faith effort and be in contact with us, and we will do our best to get it worked out with you. We will also make a good faith effort, but we cannot do the recertification on your behalf for you.
There's another question regarding the deadlines. So the research that just went out, are these for 2024 or 2025?
The formal notices that I sent are due May 15, 2025, are for 2025 annual reporting. Although in some cases me and my coworkers have been in contact with landlords about incomplete, missing, or contradictory information in late 2024 reporting as well. But for the notice that went out on April 16th, that was for 2025 reporting. Okay. This screen has useful links. And Brittany, if you could please copy, I don't know if you can do this. I was going to ask if you could copy and paste these links into the chat, but that might take a few minutes unless you can open the PowerPoint in Teams, the one I sent you. Just if you could just copy and paste the links in the chat for owners.
I put the guidelines link in the statute as well, or the
Thank you.
ordinance in there.
Okay.
But not the housing office.
Okay. Well, thank you, Jonathan. So the next question is, where are administrative regulations for the AHPP program? Jonathan has provided you an answer. If I click on this link, you can see here we have a whole document dating back to 2022, and you can also use Control F for the keyword search function and type in keywords like income. And you'll see income appears 200 times, or maybe vacant unit 9 times for vacancy, right? So you can use the Control F keyword search function and go through the document with these regulations to find policies that pertain to you. And that's what we do as well when you have questions. We will also go through this document. Thank you for sharing. So I'm going to go back to PowerPoint if I can find it. Here we go. The next link is maximum income and rent limits, and we will come back to this as well later in the presentation. But the most relevant part here is these 3 cells. If you scroll just a little bit down, one of these 3 cells should apply to all deed restricted buildings. And the question is, which of these 3 applies to you and your deed restriction? So for that, you will need a copy of your deed restriction to determine which set of maximum rent and income figures applies to your deed restricted units. So that moves on into our next subject, but let me just click open this link as well so you can see it. And here on the website, we have explained owner responsibilities, filling vacancies, and the material we need for income certification. I have not, you can see this might be a little dated. This is not the most up-to-date information, but city staff can provide that. I did want to provide this website though, because Brittany helped me and uploaded the most recent recertification material as a link in the website on this page. So we have multiple resources available online for landlords, and also staff are available for clarification. Okay, let's talk about common deed restriction requirements. My first question to you as owners and owner representatives is if you have a copy of the deed restriction. That would be very important. That will help you understand how many units are subject to a deed restriction, what we call the affordability level of the unit is. You will see what year the deed restriction was put into practice and therefore when it will expire. Pardon me. Some of the buildings have multiple modifications, 1 or more modifications to the deed restriction as well that come into play. Some of the buildings, the deed restriction will say this is an agreement between rent control, not housing, and the building owner. So there's a lot of different factors here. If you do not have a copy of your deed restriction as a property manager or owner representative, please contact us, city staff. You can reach out to me or Brittany or Richard. You can even put your name and email in the chat now and say, I would like a copy of my deed restriction. And if you put the building address, we can start and go ahead and look that up for you after this information session. If you could also provide a copy of your email so we know whom to respond to. Now let's talk for a minute about common requirements of deed restrictions. These are things we see in deed restrictions, although there's a lot of variation because obviously some of the deed restrictions go back to about like 1980 or so, and others have been signed within the last 5 years. But common themes here for deed restrictions. And these are also woven in to our AHPP program requirements that I showed you a minute ago here. So common threads. The deed restriction has to state, first of all, how many units are deed restricted. It'll state the building has, let's say, 15 units. Of those 15 units, 4 are deed restricted. I'm making those numbers up, but that would be a very common formulation, right? It has to list the unit affordability level. So what I mean by affordability level is it's going to say the 4 of the 15 units in 123 Colorado Avenue are subject to a deed restriction. Of those 4 deed restricted units, 2 must be affordable to people making X income level, and the other 2 must be affordable to people making Y income level. That income level is called the affordability level, and it's going to be a percentage. It could be 30%, 50, 80, 60, 100, or 120% of area median income. And area median income is a number that changes every year. We get updated information from the state and federal governments every year to update that number. And that's why we direct you to the city website for maximum income and rent amounts, because that number changes every year, meaning the maximum income you can accept, the maximum income that you can accept from an applicant to a vacant unit for under a deed restriction is going to change every year. The maximum income you can accept for a continuing tenant in a deed restricted unit will change every year. The maximum rent you can charge for a deed restricted unit also will change every year, and those numbers change, and we post them on our website for your review.
Nick,
Now the third, go ahead.
There's a question. Are there any resources available to share with tenants in regards to deed restrictions if they have questions?
You can absolutely. You can share any of the three resources I shared on the slide above. So any of these three you can share with the tenant, and you can also share a copy of the building's deed restriction. So the tenant is more than welcome to go through these requirements themselves on the city website. They can go and calculate themselves and double check the maximum income and rent limits. They would have to, of course, know how to navigate this and which of these three cells applies to the building, but they can do that, or they, that's that's information available to them.
And
And then
Nick,
they can also,
I would just add that every tenant should absolutely be aware that they're in a deed restricted apartment. Every lease agreement should have an addendum included that the tenant signs acknowledging that they're in a deed restricted affordable apartment and that they're aware of the obligations that they have and the landlord has for those units.
thank you. Brittany, was there a follow-up?
There
Go
is
ahead.
a model addendum that Nicholas included in that packet that was sent to all of you. And so you don't need to build that from scratch.
That's correct. Thank you. Brittany, was there a follow-up question to that in the chat?
No, that was the only question.
Okay. Moving ahead, and we will come back to that as well, time permitting. Moving ahead. So the next common component of these deed restrictions is an owner occupancy prohibition, meaning that the owner cannot live in a deed restricted unit. The owner cannot declare, I'm the owner and I am low income, so I will be occupying my own low income unit. If an owner is in fact low income, they are more than welcome to apply for the below market housing waitlist. They are welcome, if they qualify and meet program requirements, to occupy a deed restricted affordable unit in a building they do not personally own or manage. And this is also true for the vast majority of condominiums that have a deed restricted unit. There are a handful of condominiums that are subject to settlement agreements that allow owner occupancy for the duration of the current owner, but most of the condominiums are required to be rented to renters, and the renters must meet program requirements set by the AHPP regulations and the deed restriction. On a similar note, we do not allow renting to employees of property managers. So if property management ABC 123 manages fictitious building 123 Colorado Boulevard, then those affordable units, those 4 units at 123 Colorado, should not be occupied by people who are working for the property management company. Again, we understand that there may be financial need for property management employees, and we welcome them to apply for the below market housing waitlist online at santamonicahousing.org. They will be asked standard questions by other landlords as units become available, as they reach a certain point in the waitlist, but they can't occupy affordable units within their own building that they manage unless there's a specific provision in the deed restriction authorizing that.
Nicholas, I just wanted to check, are you,
Yes.
do you have a slide for this, or are we?
This would just be under common
Oh,
requirements.
okay.
Yeah.
I wasn't sure
Thank you.
because you went back to the old slide, so I just wanted to check.
No, I appreciate that. Related to this, you cannot, I regret to inform you, you cannot lease to me, you cannot lease to Jonathan, Richard, Brittany, you cannot lease to city staff who have influence over the below market housing program. That would be a conflict of interest and is unacceptable. You can lease to city staff in general if you have someone who's applied on the wait list who works for water department, parks department, libraries, even housing, but they're not over the below market housing program. Maybe they're in a different housing role, but they're not overseeing below market housing compliance. That's not a problem. But if it's someone whose name you recognize from a below market housing email, like myself, Brittany, or Richard, that is a conflict of interest. I just want to be clear about that. Now, we also want to talk about minimum and maximum occupancy requirements for these units. So as a landlord, it's your due diligence to fill available affordable units with households that are sized appropriately for the unit. So for example, if a 3-bedroom is available, it's deed restricted, it's affordable, our below market housing waitlist will automatically that's an interesting legal term. The below market housing waitlist will select households that are sized appropriately for an available 3-bedroom unit, right? So it's not going to place a 1-person household in a 3-bedroom unit in 99% of cases. Then there's the 1% where I just don't know what I don't know, but please, households need to be sized appropriately for the affordable unit that they move into and are residing in. Understood that household sizes change over time. They may go up or down, but that we just want to point out that there are minimum and maximum occupancy requirements for these units as well. There are also income requirements at lease up. So almost across the board within deed restrictions, it's going to have a formula for how to calculate maximum allowable income in the given year. It's going to have the sources of income you must consider when adding the tenant's income and assets together. And we will go through that in greater detail later in this info session. But I just want to be clear that income requirements unanimously apply or almost unanimously apply at lease up. And I say almost because there are a handful of units subject to settlement agreements where the existing tenant, is not subject to a deed restriction requirement until that person, the named persons in the settlement, no longer live in that unit. And then whomever is in the unit there then and thereafter for the length of the deed restriction is required to follow deed restriction requirements. Now, on a related note, we have a maximum allowable rent, and that's a pretty self-explanatory name. The unit rent can go up to the maximum allowable rent, and then I have an asterisk there because depending on specific landlords, that there are differences for specific individual landlords who have already worked with the city and consulted with the city, but in general, it would be up to the maximum allowable rent. If you are in a building that has rent control and a deed restriction, you may also find yourself in communication with rent control about what it looks like from the rent control side. But for us, our maximum allowable rent figures are available online, and we expect landlords to be able to go to the website posting maximum allowable rent numbers and correctly calculate maximum allowable rent for tenant units. We do get tenants who come to us asking us to confirm the landlord's calculations for maximum allowable rent when the tenant's rent gets increased annually. And so we want to make sure that we're on the same page about how it gets calculated. So there's, we can minimize the number of confused tenants or tenants who find out that they're being overcharged, which of course would affect how they are willing to communicate or cooperate with not only landlords, but with below market housing staff moving forward. So we just want to be all on the same page about maximum allowable rent and how to calculate that. There's also very commonly an annual reporting requirement within deed restrictions, meaning that the landlord or the landlord representative must submit an annual report to the city, and it's going to have things like how many people live in the unit, has the unit's composition changed, has the unit been vacant, how much are you, the landlord, charging the tenant. It will have information like that, and we provide a standardized form to facilitate that for free online through santamonicahousing.org. So we encourage you to do your annual reporting digitally. There's a copy for everyone involved, and we can review it that way. You are also, in a majority of cases, required to notify us when the unit becomes vacant, when it is a deed restricted unit. If you are that fictitious building at 123 Colorado and one of those 11 non-deed restricted units is vacant, you do not need to tell us. It is not our business. You do not need to recertify those other 11 units. It's not our business. Who lives there? What's happening? That is between you, code enforcement, maybe, if something comes up, and the tenant. However, for those 4 deed restricted units, you do need to tell us if the unit becomes vacant. And again, we offer you a chance to do so for free through our santamonicahousing.org portal, where you can just select that the unit is vacant, but you could also just send us an email. Anything in writing will suffice. So you would want to tell us which unit is vacant. And in a lot of cases, there is a requirement in the deed restriction that you then select somebody off of our city waitlist. And our city waitlist, like I said, will select tenants for you based on the unit number of bedrooms and also the unit affordability level. So as long as you have the correct number of bedrooms and the affordability level on our portal, the portal will be pulling people from our waitlist and selecting them, sending them to you in batches so that you have people whose reported household size and reported income, self-reported income, matches what you have put into the portal as well on your end as the owner representative. Duration of the deed restriction agreement. Typically, that would be 55 years. I think I've seen one that was shorter than that, and that one was signed in like 1980 and expired in 2010. So the standard length would be 55 years. And last but not least, a prohibition on unauthorized occupants and subletting. So a deed restricted program, a deed restriction program is to create and maintain an inventory of affordable units for low-income people who need housing. So what this is not a program for units to be used as a quasi-hostel by the primary tenant subleasing additional bedrooms to other people. That's not the intent of this program. It's also not the intent of this program to have tenants in their affordable units because they're low income or state that they are low income and then lease the unit on a vacation rental sharing website. And so for a lot of our deed restrictions explicitly prohibit that. The program regulations also prohibit that. And to go on to my next point, actually, we're going to talk about general compliance, which extends beyond just your strict deed restricted units into just general kind of housekeeping tips for best practices for maintaining ease of communication with the city regarding tenant complaints, because we do have tenants who come and make allegations or have a situation occur, and we want to make sure that the situation is resolvable, and we just want to prevent things as much as we can from becoming more complicated than they need to be. So with that, I'm actually going to go ahead and click on the next slide. So I touched on this a second ago. We want to talk about general compliance with the city's home sharing ordinance. Santa Monica does not allow, in any case, a tenant to list their unit as a vacation rental like Booking.com, Vrbo, Airbnb, etc., and not be in the unit. That is not allowed at all, whether or not the unit is deed restricted. In Santa Monica, if anyone's listing their unit as a rental on Airbnb, the host has to live in the unit during the time that the guest, the visitor, who has booked the unit on Booking.com or Vrbo is in the unit. It could be something like John or Jane Doe has a 2-bedroom back house. They want to rent the second bedroom to guests and visitors of Santa Monica. They need to get a permit. They need to go through the city and get a permit. We do not issue the permits, but you would apply online or you would apply through another department in the city, get the permit. And once you have the permit, you need to follow the city's home sharing ordinance, and the tenant needs to be present during the times that the visitor is in the unit. I say this because if it comes to our attention that a unit is being used as Airbnb and the reviews on the Airbnb mention things like, it was a great unit, had it to myself, looks brand new, clearly no one's ever lived there, that again is an indication to us that the tenant was not following the home sharing ordinance, on top of the fact they may or may not have had a license from the city, on top of the fact that their deed restriction in many cases will not allow posting the unit on Airbnb, on top of the fact that it goes against the AHPP program guidelines. The tenant, even if the tenant followed all of the processes and got their license, the tenant would have to be present in the unit during those periods of rental to guests as well. I just want to be clear.
And so I would just add very quickly, if the landlord, knew about that or should have known about it, that is a violation of their legal obligation to comply with the deed restriction. So, it's important to enforce those restrictions where a landlord knows that there is those kinds of short-term rentals occurring.
Yes, the landlord has the obligation to act in good faith and in due diligence. So if other tenants are coming to the landlord saying, hey, I'm really getting bothered by what's happening in unit 123. In unit 123, there's random people showing up at any hour of the day from LAX. They're knocking on my door. I'm across the hall. They're saying, how do I get into my unit? This is my vacation. I can't get into my rental. And the landlord gets notified of this and then doesn't do anything. That could be a problem for the landlord. So if you are aware, if you get notified, it's under everyone's best interest for you to act on that and report it to code enforcement. Go ahead.
And the one other thing I was going to add quickly was that not only would that often be a violation of a requirement listed in the deed restriction related to subleasing, but also if the income generated from even a lawful permitted home sharing puts the tenant over the income threshold for the unit, that would also be a violation.
Thank you. Now, going on here, so this is on a related note. As a landlord, we would expect that you maintain copies of rental applications, right? So especially for deed restricted units, if there's a question down the road, hey, does this person actually earn less than the deed restricted amount? How many people are really in this person's household? Like, it seems like there's a question about whether there's unauthorized occupants, or we don't really understand what's going on here. That's when it's so important for the landlord to have maintained clear records since the tenant's initial application. We can and will request copies of this from you. We can and will say, can you give us a copy of this person's rental application? We want to see what that person said their income was when they applied. Can you show us, did that person actually provide proof of income to you? Like, did they provide a pay stub? And as a landlord, you're getting paid for rent. So it's not an unrealistic request of us to say, did you actually check if the tenant has any income before you lease them this deed restricted unit? That's in my opinion, that's a very reasonable request. And so as a landlord, I would encourage you, maintain copies of these rental applications, maintain a copy of the lease you sign with tenants, including like who's on the lease, who's the authorized occupant, and copies of lease addendums, like the affordable housing lease addendum that Jonathan mentioned earlier. We will come back to that. And then there's also this component about just cause eviction. So if there is something that's not quite right with the unit, the tenant is doing something that they shouldn't be. The tenant is causing a disruption. They're using Airbnb. They've misrepresented something to us. Then you, the landlord, you are responsible for making sure that that unit that you manage is in compliance with the AHPP program guidelines. We may provide information to you. We are not lawyer. Well, I'm not a lawyer, so I cannot provide you legal information. The city attorney's office will not be representing you or acting in such a capacity either. But we can provide information, and we may even write you letters, which I might add are subject to Public Records Act requests. But ultimately, as the landlord, it is your responsibility to enforce the program requirements and the deed restriction requirements. And if you do not do so, you are opening yourself up to consequences. So before I continue with that, Jonathan, could you please explain some components of the just cause eviction ordinance and how that might pertain to a situation where tenants may have violated one or more things about deed restrictions or complying with their lease in general in a deed restricted unit, and how that factors into the landlord's communications with the tenant if that's the case?
Sure. So pretty much every rental unit in the city of Santa Monica, with the exception of some condos and single family homes, which is not likely to apply here, are subject to just cause for eviction, which is set forth in the city charter. And basically what that means is that a tenant can only be evicted for a specific set of reasons that is listed out in the city charter. So the most common ones that you'll see would be non-payment of rent, violation of a lease. There are a number of others, but those are the ones that you're likely to see for a deed restricted unit. Now, Richard mentioned earlier in this conversation the importance of a lease addendum. Just for the tenant to be aware of what their rental situation is. It's going to be important for them to sign that, but it also has an important legal purpose. Because a tenant can only be evicted again for that specific set of reasons, and that city charter does not list out there explicitly, non-compliance with an applicable deed restriction. It's possible that could change in the future, but that is not the case right now. And so that makes it vitally important in terms of a landlord's ability to stay compliant with their deed restriction that they have the tenant sign this addendum, which makes clear that the tenant has an obligation under their lease to comply with the requirements in the deed restriction and simply to remain qualified in terms of income and the number of occupants. If you don't have that addendum, there could arise situations where, although a tenant is over income or otherwise doesn't qualify or something else is going on, it could pose a challenge to removing them from the unit in order to provide that to an income qualified person in order to comply with the deed restriction. In those cases, the housing division, and if necessary, the city attorney's office does still enforce the deed restriction. And, we have to consider other kinds of remedies in order to make sure that the public is getting the full benefit of the restriction. That could include if we're not able to reach some kind of an agreement, a lawsuit for damages, and sometimes we will also ask for extending the duration of the deed restriction to make up for time in which the public benefit of having an income qualified person has not been provided. And so again, the lease addendum here is very important, both for the information that the tenant should have, but also because given that just cause for eviction requirement, it may be a necessary tool in order for you to enforce the deed restriction. One other quick note, I saw in the chat that there was this question about reporting short-term rentals to code enforcement. And I just wanted to be clear about something, which is that, yes, it is a good idea to do that, and we want those to be reported to code enforcement. But it's not the case that a property owner or management can simply report that and then say, okay, I've done my piece and wash their hands of it. The landlord has an ongoing obligation to make sure that they're in compliance with the deed restriction. And that means that if a tenant is subleasing or if they're not living in the unit, and therefore the landlord is in violation of their obligation to have an income qualified tenant living in that unit, they have an independent responsibility to enforce the deed restriction and make sure that that tenant comes into compliance. And so one other thing to note about the just cause for eviction requirements is that there is a warning notice requirement. And generally speaking, for a curable violation, you have to provide reasonable notice in writing that gives an opportunity for the tenant to cure, to come into compliance with whatever the lease violation would be. And then if they don't comply during that period, that can be followed up with with an eviction notice. And so, for example, where if a tenant is Airbnb-ing and the landlord knows that, whatever code enforcement does or doesn't do, the owner and the management of the deed restricted property has an independent obligation to enforce that deed restriction, which would generally start with that warning notice, giving the tenant a reasonable amount of time to cease that subleasing, come into compliance, and occupy the unit as an income qualified household with the correct number of occupants.
To go off of that, and thank you. The opportunity to cure can look different depending on specific circumstances. So it could also be that we have reason to believe that tenant X has not lived in the deed restricted unit. So within X amount of time, the tenant has to verify that they, contrary to what we believe, actually have been occupying that unit. That could be another example. Or the tenant has misrepresented their income. The tenant does not have X amount of time to quit their job and lower their income. The tenant has X amount of time to demonstrate that, contrary to what we understand their income may be based on the partial or the full reporting we have available to us, the tenant has their opportunity to present additional information or clarify something as well. Now, moving to my next point here. Who may enforce deed restriction requirements? And I want to be clear that that is literally almost everyone in the city of Santa Monica. So the city is first, of course, that's why we're on this call, city attorney's office, housing division, and I want to again reiterate that when we write these letters to owners saying your reporting is late, your reporting is incomplete, please clarify this or that, we believe that you are not in compliance with the deed restriction. Those letters are publicly viewable and discoverable through a Public Records Act request, meaning that by the time you get a letter like that, an attorney from a tenant, legal aid foundation, reporters, researchers at universities, random citizens who are just curious, any of them can obtain a copy of that letter. And I just want to be clear. Also, who else can enforce deed restriction requirements? Your own tenants. Your own tenants, whether or not they live in a deed restricted unit. Maybe you have a tenant who lives in a market rate unit who wants to live in a deed restricted unit. They also can enforce deed restriction requirements against you as the landlord or the owner representative. The general public, that could be somebody on a Santa Monica resident on a below market housing waitlist who's trying to get into a unit faster, and they're frustrated that they feel for whatever reason that the existing arrangement is not following deed restriction requirements. They can enforce it as well as someone on the waitlist or a member of the general public. We have also had multiple people contact us as former vacation rental customers. These are people who come to us, phone, email, and they say, hi, I'm John or Jane Doe. I actually just rented XYZ building, XYZ unit last week on Vrbo or Airbnb. I stayed in the unit and then the neighbors told me that I shouldn't be in there and it's an affordable unit and I feel very uncomfortable with what happened. So here's my receipt. Here's the copy of my stay and the confirmation. We also get those as well. And so those people can enforce deed restriction requirements. So can people who live in other buildings, like whether or not the unit is deed restricted, they could live in a general building with no deed restrictions. They could live in an older deed restricted unit and want to move to a newer building with deed restriction requirements. They can enforce as well. And last but not least, banks and lenders also. So we get requests periodically from landlords who say, hey, I'm trying to sell XYZ building, which has a deed restriction on it. And I need for this transaction, I need the bank. The bank is telling me you have to get a compliance letter from housing division. You have to get verification. You are following deed restriction requirements before we will process this transaction at our bank. So that could also be you. It could be the bank requesting and enforcing deed restriction compliance. So I just want to be clear that you don't have to wait for city staff to follow up with you for deed restriction compliance. It could be any number of entities have the legal right to follow up with you on that. Now, I also want to point out here that compliance is mandatory whether or not the city sends you a notice to complete your annual reporting requirements. So in the event that something happens again, like COVID, God forbid, that obviously disrupted city operations. In the event of a similar disruption, unfortunately, perhaps there was a natural disaster, perhaps there was mass layoffs, the landlord must still, regardless, comply with their deed restriction and program requirements, whether or not we send a notice. Now, I want to bring up one more thing, the final point here on this slide, and that is how we handle non-compliance for tenants and landlords. Generally speaking, the landlord is responsible for ensuring tenants and tenancies comply with deed restriction requirements, and we've just talked about that, myself and Jonathan here. Now with landlords, and there are cases where the city may directly reach out to tenants as well, or the tenant for that matter directly reaches out to the city. That does happen, but generally speaking, the landlord is responsible for enforcing. They have their own responsibility to enforce deed restriction requirements on the tenants. If that is not happening, if the landlord is not up to speed on the requirements or hasn't been enforcing things they should have been, that is where the city will become involved. So the city is the entity, one of the entities that we just discussed that will follow up with landlords to ensure compliance. Although, like I just mentioned, we are far from the only entity. We are one of them, and landlords are responsible as the primary. They're the primary entity responsible for tenant compliance. Now, before I move on, I want to ask Jonathan a question. What happens in instances where the landlord does not comply with deed restriction requirements?
Great, thank you. So generally speaking, enforcement will start with the housing division. We take in situations where there's good faith on behalf of the landlord and whatever may have happened, there appears to be non-compliance. We take a approach of open communication and try to work together to come to a resolution. If there is either non-communication or communication that doesn't suggest a good faith effort to try to come into compliance with program requirements and with the deed restriction, then that may be escalated to the city attorney's office. Now, our office can and does bring civil lawsuits to enforce the deed restriction. If you look through your individual deed restriction, there is a remedies provision. It generally has quite broad language that says something to the effect of, that the city and the other folks that have the right to sue can obtain, the remedies necessary to enforce the deed restriction. There's also almost always an attorney's fees provision, which basically says that if the prevailing party, if the city were to bring the lawsuit, that would be the city, were to be successful in the lawsuit, then they would be entitled to not only whatever damages they would get, but also to attorney's fees. And attorney's fees would not necessarily be the actual rate of pay for myself or the other attorneys working on the case, but a generally accepted market rate for attorneys in the Los Angeles area, which would be quite a bit higher. In terms of remedies in such a lawsuit, I guess one of the things I should say is even if we get to the point of filing a lawsuit, we want to make sure that we're getting an appropriate remedy, but we remain open to discussions into settlement. And so prior agreements have included things like clarifying and strengthening remedy provisions in a deed restriction, lengthening the term, which sort of makes sense if there's been the public benefit has not been provided to the public because there are over-income tenants or excessive rent has been charged, then that benefit needs to be provided going into the future to ensure that that whole 55-year term is satisfied, as well as potentially money damages that could be obtained, amounts to cover, for example, getting back excessive rent that was obtained for units that where tenants were overcharged, or redeeming the lost value to the public for over-income tenants, for example, or deed-restricted units that are not provided, which could be calculated in different ways, including, the difference between a market rate for a similar type unit and the deed restricted amount that should have been provided, which would be a sort of measure of the public benefit that was lost by either having an over-income tenant in a unit or not providing a restricted unit. The other thing that I would note is that the city of Santa Monica has a long-standing practice, and tenants are generally aware of this, of actively enforcing not only these deed restriction requirements, but also our tenant harassment ordinance. And so we have an open complaint system where tenants will file a complaint with our office. And we do investigate those and enforce any violations that we find. And so similarly here with deed restrictions, we keep track of all of the cases that we have, and where we reach an impasse or we don't have other options, we will go to court to enforce the deed restrictions.
And to me, this comes back to the importance as the property manager or the owner representative of maintaining copies of information like the tenant's initial rental application, the leases you signed with the tenants for the deed restricted units, any notices you served, such as a notice of abandonment to the unit if the tenant is not living there for an extended period, a notice of violation, maybe with the opportunity to cure, And then also proof of rent payment to prove that the tenant actually is paying rent and is a tenant versus, I don't know, some other non-tenant person living in the unit. So with that, we have some time for a question break for landlords. So landlords and people on the call who are here representing owners, please feel free to send us your questions. I'm eager to hear what you have.
I do see one question in the chat.
What if the tenant is non-compliant with filling out the paperwork? What can a landlord do to get the paperwork done? Thank you, Lavana, for your question. If it were me, I will be very unhelpful here and start by saying I'm not a lawyer, so what I'm telling you is not legal advice. Having said that disclaimer, if it were me, I would be asking the tenant in writing, right? So, dear tenant X, I am writing to confirm our phone conversation this morning in which you stated you will not be providing information to recertify your income eligibility for a deed restricted affordable unit. I am in this email, I'm confirming that this is a requirement of the AHPP program guidelines and you are violating the guidelines. At that point, our standard procedure is someone who doesn't want to recertify gets a 12-month notice.
And again, I would reiterate the importance of having that lease addendum that every tenant should sign. If for some reason a tenant has not signed one at the initial lease up, which should be done for every single deed restricted tenancy, you'd want to have that signed with the tenant as soon as you're able to have them do that. Because again, that's what's one of the things that will give you the authority to go ahead and serve a notice for non-compliance with that lease addendum, which will include, again, qualification, but also the need to provide the paperwork for recertification.
Additional questions?
There's one that says, in the addition to the addendum, does the city have other approved forms and example notices that landlords can use and rely upon?
I asked the person with this question what kind of notices would be helpful.
Sorry about that, Nicholas. It's CJ Laffer. Really, I think at one point earlier in the webinar, you alluded to providing notice. I guess maybe separate and apart from the addendum, notifying tenants, for example, at the inception of the tenancy that they are subject to an affordable unit, or really anything, any and all notices that might arise during the tenancy that that the city accepts as legally adequate for purposes of compliance.
Thank you.
Yeah, I mean, I think that it's a best practice to have all of the necessary information in the lease addendum itself, or certainly provided with the lease. And so again, there is that model there. And also to provide a copy of the deed restriction itself to the tenant at lease up, or if they don't already have it, as soon as possible. In terms of, I'm not exactly sure what other notices you're maybe thinking of. We can't generally provide legal advice in terms of things like a warning notice or an eviction notice. We can try to provide information again about that just cause for eviction ordinance or other questions on a case-by-case basis. Certainly, if there are other specific forms that you think would be helpful, you can let us know and we could look into that.
Brittany, is there any other questions in the chat?
No, that's all.
Thank you, Brittany. So with that, we are going to jump right into annual reporting and compliance expectations. So to start with, which unit must a landlord submit reports for? You must support one report per deed restricted affordable unit per year. Let me explain this to you another way. Let's say that you have one affordable unit. It's a 4-unit building. One of those units is deed restricted. The deed restriction standard length is 55 years. So over the length of the deed restriction, the city should end up with 55 annual reports for those 55 years. It's not acceptable if the city ends up with 20 reports for a 55-year period. That does not show compliance with the deed restriction. If the unit is vacant, you do still have to recertify it. You have to report it. The process is simpler than for occupied units. If the unit has voucher holders in it, the process is simpler than with non-voucher holder tenants. And we can go through that in a minute. But the bottom line is, if you're a landlord and you have 15 deed restricted affordable units, at the end of 2024, I should be able to go into our portal, santamonicahousing.org. I should be able to type in your address and I should see 15 complete annual reports, each one representing 15 deed restricted units. I have seen landlords submit multiple reports in 1 year for 1 unit. I don't know if that was intentional or not, but submitting 15 reports for 1 unit when you're supposed to submit 15 reports for 15 units does not demonstrate compliance. So with that, I'm actually going to pull up the portal here using my screen share. Let's see how the internet connection's going. Here we go. And this is how the portal looks to me when I log in, and it will look broadly similar to you, but there will just be fewer opportunities, fewer selections to make on the left side drop down. So normally as a landlord or owner representative, when you log in, it'll say your name, it'll say your agency instead of City of Santa Monica, and then it'll have like a drop down here. It might even say cases. So you click on cases and it's going to have like 4 options instead of all of these, right? One of them is manage manager resources. So I just want to go here so you can see it. If you click on manage manager resources, this is where we have extra copies of these forms. So if you should ever need them, this is the repository. So we have a recertification user guide. It loads. This goes through the step-by-step process for here we go. And let's see if it will open. Perfect. And you can see here it's about 18 pages, but a lot of it's very visual. It has screenshots. It tells you what button to click. This is how you submit annual research, okay? This is how you submit your password. This is how you get your profile set up. It's very useful, and I send it individually as an attachment to people often who are trying to get their profile set up. But I just want you to know, if you log in successfully, it is available to you at any time under Manage Manager Resources. Oh, poop. Here we go. Referral request guide. This is related. I'm going to see if we can open this. Now, the referral request guide is for filling available units. So those of you whose deed restrictions say you must take units from a city approved list, we are talking about santamonicahousing.org. This has a step-by-step, tons of visuals, very colorful screenshots, and it will show you how to get that request in and submit it. My coworker, Brittany, who's been helping me with this presentation, is your primary point of contact, although you may have to deal with me instead if she's out and I'm not nearly as good at this as she is, but one of us will get back to you, usually her, regarding your referral request for information or updates. And this is your how-to right here on the website under Manage Manager Resources. I just want to advertise that to you. The third one, or the fourth one, is a copy of the lease addendum as a standalone item. Right here. I do not know why it has my email listed. It shouldn't. Maybe that's just because I'm opening it from my laptop computer, so it auto-filled it. We can delete that, but it's fillable online. So you and the tenant can each type in the relevant pieces of information, save it, and then upload a copy to the portal for record keeping purposes. So that's also right here. It's a standalone. It's not part of the whole recertification packet. We do have that too. That is the first item because of its significance. So let me click on that just to show you the new updated forms. Of course, most of you have seen this. All right, these are the new and updated forms, and this is what we're talking about for the remaining portion of today's info session. So it should be pretty self-explanatory. Everything here that's highlighted blue is for the tenant to complete. We have a tenant checklist telling the tenants very clearly what they need to do to turn in complete and accurate information to us. So we have, a step-by-step checklist right here for the tenant. We clearly state this does not apply if you are a voucher holder. Do not complete this form. Only non-voucher holders. Then there's a questionnaire. The tenant needs to say yes or no to all of the yes or no questions. It is not acceptable for the tenant to leave questions blank. It is not acceptable for the tenant to just click one question and then scroll down and sign. That's not acceptable. The landlord must review the information the tenant's submitting. The landlord must review the tenant's completeness of the tenant questionnaire here. If the tenant says, no, I do not have an IRA, and then they submit a pay stub that shows a deduction to a retirement account, that's not complete because it's inaccurate information. And we'll come back to that. But I just want to show you the general layout here of the packet. We then have highlighted in yellow the landlord checklist. This is for you. This is helping you go through so you can keep track of what you need to be looking for from tenant information. Every tenant, every adult in the household, if there's a three bedroom unit and there's 3 adults in that 3-bedroom unit, you need 3 copies of this form, 1 per adult, unless the only exception is if the adult has a legal guardian. Maybe there's someone who needs a little assistance in their daily activities. If they have a legal guardian, the legal guardian can complete this for that person. Other than that, if it's 3 adults, we need 3 copies of this form. We need 3 people's bank statements, 3 people's pay stubs as applicable, 3 either copies of their tax return or 3 declarations they did not file, unless, 2 of them are married and the third person's maybe the parent who's listed as a dependent. Then I could see 1 tax filing. But otherwise, every single adult needs a tax filing or a declaration they did not file their taxes. Moving on, this page is self-employment business verification. This is for people who either own a business directly or are self-employed without owning a formal business setup. And again, like with anything that a tenant declares up here in the yes or no section, a tenant must provide supporting documentation. It is not acceptable for a tenant to fill out this section and say, I'm Joe Schmo. I own Joe's Arts and Crafts Incorporated. You can reach me at 310-456-7890. I promise my income last year was $2,000. Sincerely, Joe. And then they provide no backup documents. That's not acceptable and that's not complete. So right here in the middle of the page, we tell the tenant, you must provide information using one of the following methods below, supported by documents requested and attached to this form. The easier way to do this is the tenant provides their most recent tax forms. By now, it's April 28th. Those who have submitted their 2024 tax filing can provide that. They need to provide all of the schedules. If you are self-employed, in some cases, there's going to be a lot of schedules attached. So just completing the 1040 portion and not the schedules for someone who's self-employed and has those extra sections is not acceptable. They need to provide the whole thing. If they're claiming they did not submit taxes at all, that's okay. They can instead submit business bookkeeping records for the last 12 months to show their net business income. But they need to provide one or the other. They need to fill this whole section out. They need to say my net business income is whatever it is. I do or I don't receive regular wages. Select one or the other. It's a yes or no question. Sign, date, and print. That's for the tenants who have businesses or are self-employed. Page 7. Now, page 8 is for tenants who are getting financial aid, basically, from friends and family. And you may find this by going through their bank statements and seeing recurring contributions and seeing every month it looks like Janice so-and-so is giving the tenant $500, $800, $80, $200 in Zelle, Venmo, Cash App, e-transfer. If that's the case and you're seeing that on the bank statement, whether or not they declared it up here, which they should, the tenant and the person giving the tenant this money needs to fill this section out. And they need to give it accurate information. If they say it's 200 and the bank statement says it's 800, that is not acceptable. Do not accept incomplete or obviously inaccurate information from people giving you info. If you are looking at the bank statement and you see a lot of cash coming in from friends and family, and the tenant comes up here and the tenant's claiming no to question 3, which is saying I receive regular cash contributions and gifts from people not living with me. And they said, nope, not me. And then you look at the bank statement and you see Zelle, Venmo, Zelle, Cash App, Zelle. They need to go back. They need to correct it. This form, it's very important that this questionnaire is completed for every adult in the household and that all the questions are answered yes or no. And also that the tenant's responses actually reflect what you're seeing as a landlord in the supporting documents the tenant needs to provide. So
Nick,
before I move on, do we have questions? Go ahead.
yeah, there's a question asking how many months of bank statements are required? The last 2 or 3 months?
So it's 3, and the reason being that tenants will sometimes say, I don't like that you're taking my cash payments as income. That's not fair. It was my birthday that month. November was my birthday month, and that's why people gave me money. That's fine, no problem. We're going to take September, October, and November. We're going to average it between the 3 months. So it's not going to totally skew things. If it's in fact true, you got a lot more money in 1 month than the other 2, no problem. We're taking an average. That's why it would be 3 months. Any additional questions before we move on? I'm going to go back. Oh, I see one more person. All right. I'm going to go back to this section on the portal. We have now covered manager resources. This is occupancy reports. And I want to be clear that an occupancy report is basically an annual report per unit. It's one occupancy report per unit per year. To start one, you go over here. Obviously, on the left, you've clicked Manage Occupancy Reports, and then you click the green button on the right saying New Occupancy Report. This is what it will look like. Since we are now in 2025, you would click year 2025. If this were January 2025 and you were trying to get up to speed on your late or incomplete 2024 research, maybe only some tenants turn them in and not others, and you're just getting late information, maybe then you would select 2024 from the dropdown. But we are now in 2025. We're talking about the research that are due May 15th, 2025. You will select 2025, not the previous years. For your building, you would type in the building address and it should select here from the dropdown. If it doesn't, then that is a good reason to let us know right away. Likewise, with the apartment number, that should also select from the dropdown. If I select a random building, let's say I select this one, the apartment number should pre-fill. And then you would go from there. If that is not the case, like I said, please let us know. When we are talking about vacant units, that is right up here at the top. So let's say that the unit is indeed vacant. You'll see the form updates, and a portion of the form just disappeared because we don't have tenant income to report. The unit has no one living. You would instead put what date the unit became vacated. Maybe it's been vacant since February 4th. Does the household income exceed maximum allowable? No, because there's no one in there. Can you certify this unit is in compliance with the deed restriction? Well, I hope so. I am an agent of the owner. My name is Jane Doe, John Doe. Hey, we're going to put the date. Very well. Scroll to the bottom. For a vacant unit, all you do, you click Create Occupancy Report. That is literally the entire process for reporting a vacant unit, which means it's not, well, you'll get the hang of it, but it's not an onerous process. So please report vacant units. I just want to reiterate that on this call.
And
It's
this
very
reminds
important.
me, I'm not sure if Nicholas may have already mentioned this, but almost all deed restrictions also have a requirement to diligently try to fill vacant units within 60 days. And that is a requirement that we enforce. So this includes, buildings that have been around for a long time or new buildings. You can't, prioritize the market rate units and kind of ignore these units with lower rent. They need to be treated the same as the other units, and diligent efforts need to be made to fill those vacancies. Certainly within 60 days, and should be a shorter time period than that, given that it generally takes only a few weeks to fill a unit.
Thank you. Now, I want to go through 2 more things before I move on to the next point here. One of them is, let's say you turn in something on the portal for a unit and you need to update the information. Something changed. You have new information. Please do not create multiple reports. Do not go and create a new occupancy report for a unit you have already submitted that year's report for. If you have already submitted a 2025 report and you're like, oh, I think I need to change something, your already submitted 2025 reports should populate the screen, just like you see here. All these submitted reports are populating. Yours should populate for your building right down here. And you can use even a filter button if it appears for you. You can use the drop down to scroll down faster depending on how many you submit for your building. But you would go to that particular report. Let's say it's the 2025 report. You go to that one and you can upload or edit information in it, no problem. But please do not submit multiple for the building. So that is one point here. And then the next one is, how do we complete the process for voucher holders? So I'm literally on the screen. Let's take a look. You're going to select the building. I'll pick one at random. You'll select a unit. Is it vacant? Hold on. There we go. Is it vacant? No, there's a tenant in there. Tenant, first name, Jane Doe. Is Jane older than 62? No. Did she move in the last 12 months? Yes or no? Let's say no. Number of occupants, however many. 1. Voucher, yes. Apartment, number of bedrooms. You select from the dropdown, however many. Income level. This is what we were talking about earlier. If you are not sure the income level, please refer back to your deed restriction and select the correct amount. We see a lot of landlords just leave it at 30 because that's the first option on the dropdown. It's usually not 30 because 30 is the lowest rent unit, and there's actually a lot more in the higher tiers because of the state density bonus law. So please be sure to correctly fill out this particular field and make sure that this reflects whatever is in your deed restriction, because I have tracked it and there's a lot of inaccurate reporting of the income level for the unit. This is also important for reporting vacant units, because if you just leave this as 30% and you have a vacant unit and you put it on the wait list, you're going to get a pool of applicants we're referring to you that doesn't actually reflect who should be referred to you for your specific unit if it's at a higher tier. If you leave it at 30%, the people we're referring to you will be very low income, and they're not going to be able to necessarily pay unless they have a voucher, they will have a hard time paying the level of rent that you would be allowed to charge if you have one of the units at one of the higher levels. I just want to reiterate that. If the unit has mobility features, you would click these buttons. Now, down here, we have all these drop downs about which utilities are and are not included in the rent. And these are also important because I want to reiterate that your maximum allowable rent, as shown on the website, must factor in tenant paid utilities. So if a tenant is paying separately for electricity, let's say the tenant pays separately for electricity, it is your responsibility. Let's say that the online table shows the maximum allowable rent's $1,000. Tenant pays separate for electricity. You have to look under the utility allowance for 2025, which is available on our website. I can pull it up and show you this right here, right? We're back on the page with maximum income and rent. You scroll down to the third cell. We have the link right here, 2025 utility allowances. And this shows you what we're crediting the tenant. If the tenant, for example, is paying water and they are in a 0-bedroom unit, already, if the maximum allowable rent on the table is $1,000, but the tenant pays water separately, you are now down to $916 as the maximum allowable rent, because we're factoring in that 84 the tenant also pays for water separately to the water company. I just want to point that out. So going back here, that's why we ask you to fill out the utilities, make sure this is correct, because this is one of the features I'll use. If that tenant comes to our public counter and says, what is my maximum allowable rent? I may be going through your report to verify, well, the landlord says it's this and this. And, oh, you're saying differently. Okay, well, you need to clarify that. It would be helpful for all parties involved to keep the process smooth and problem-free if you can make sure that this is accurately reported on your annual reports. Does the household income exceed the maximum allowable income? Big question, yes or no, or NA for, I guess, for vacant unit, but I didn't even see that question for vacant units. NA might be like a unit that was subject to a court settlement. You certify yes or no, you put your name, And then down here where it has the option to upload, this is where you're uploading the completed tenant. Is it here? No. This is where you upload the completed forms we just went through that show where the tenant fills things out. They have to fill in the checklist. You and the tenant have to sign certain documents. You would upload the completed form here along with tenant bank statements, tenant tax return copy, tenant pay stubs. You can upload it as a single file or you can upload it separately, but you would just choose the file. And then here you have the different options you can upload. And you would select the type of file, scroll down, create occupancy port, click, and you have submitted. So,
One question for the
yes.
utilities. Does the electricity bill affect the max rent allowance, since that is billed directly from the utility provider?
Yes. But it's not the amount the tenant paid. Like the tenant can show you, they can be like, I paid SoCal Edison, I paid, whomever, I paid them $135 last month. That's irrelevant. What you would do is you would verify that, the tenant is not paying, the tenant has to pay electricity separately. You go to utility allowances, you say how many bedrooms are in this tenant's apartment? Maybe it's 2 bedrooms. And then you say, okay, so which of these apply to the tenant? Well, in this case, the tenant has to pay other electric. Now, the tenant might also have to pay electric for their heating or cooking, in which case you add those relevant figures as well. But just for other electric, 2 bedrooms, okay, if the original deed restricted amount was $1,000, now it's $950 because they're paying separate for electric. If they're also paying for electric cooking, instead of $950, it's now $932. If they're paying separately for electric heating, instead of $932, it's now $896. That's how you do it. You subtract the separate tenant paid utilities from the maximum allowable rent, and you also subtract mandatory fees. If you are charging the tenants a fob fee every month, a clubhouse fee, a credit reporting fee, a personal liability insurance fee, a renter's insurance fee, any and all of those also get subtracted from the maximum allowable rent. And we send out a notice as part of our research packets to verify that as well. And we will explain that to tenants if they come to us. Questions? Now, one final thing I want to say here is that although you just saw the process for current voucher holders is short and sweet, you do have to report that they are living in the unit, the number of people in the unit, the amount of rent you charge them. It is, like I showed you, it's up on the website. This reverts back if the tenant gets terminated from the voucher or just decides, their income increases enough, they are no longer receiving a voucher subsidy. Now, even though at one point they used a voucher to pay you, now they're paying the full amount. They have to complete the full process. I just want to clarify that. If you are not sure if the tenant is currently receiving rental subsidy, you are welcome to reach out to us and we can confirm as well. Okay.
There's a question.
Yes.
Where can you report the utilities in the occupancy report? If you still have that open.
Right here in the middle section.
And one last one, what's the annual allowed increase for affordable rent?
You will see the updated charts here every year. So they do update around this time of year. You can see right now we have 2 of the charts updated and the third one is pending information from the state. So the first 2 we got info from the federal government, so we were able to update them a month ago, and the third one is still pending. And the third one is using 2024 data still. So you basically would just understand that annually our numbers update around this time every year. We publish on the website, like you can see when the numbers change, and then you would click on the chart pertaining to your building and you can see what the new maximum allowable rent is for the affordability level and the number of bedrooms before you subtract mandatory fees and tenant paid utilities. If you need the numbers for a previous year, like you want to see what the 2022 numbers were, that's okay. You can reach out to myself or Brittany and we can pull those numbers for you.
And I did want to just make clear as well that you still have to provide the mandatory state law notice period for any rent increase. So that's going to be generally 30 days, or in the rare cases where it would be above 10%, that's a 90-day notice. And again, I'll reiterate that there are price gouging protections that are still in effect after the fires, and that those generally limit increases to 10%, and that's even if you're more than 10% below the deed restriction maximum. That's more or less a hard cap on an increase of any kind under any circumstance while that emergency is in effect. There are somewhat different rules for a rent-controlled unit that becomes vacant. That's going to be rare for these deed-restricted units, but you can reach out to us about that.
Thank you. So we're about to jump in and go back through that tenant recertification form that you, the landlords, and the tenants will both sign, but I just want to be clear and go through some key points here first. The first thing I would do, so I've already mentioned that each adult needs to complete a separate copy of the form. The tenant cannot simply self-declare whatever they have and submit the form. That's not acceptable. So for example, if I scroll up to page 1, the tenant cannot simply like fill out no, 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 yes, yes, no, 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 signed Tommy tenant, date April 28th, 2025, signature here. Great, I'm done. And then the landlord's like, great, me too. I sign, I date, and I upload. That is not complete. That is not a complete recertification. The tenant absolutely must provide third-party, relatively recent, same year, documentation for whatever income and assets they are declaring. And you need to review the materials that they're providing. So they say they have a bank statement, they need to give you the bank statement, and you as the owner need to review the bank statement. The bank statement should be consistent. It should be in the tenant's name. It should show a mailing address in Santa Monica, especially if they've been in the unit for a period of time. It should have amounts coming into the bank account that make sense for the affordability level. If the tenant's declaring that their income is $40,000 a year, and you look at the bank statement and it has $10,000 a month in deposits, that's a big red flag. That is the burden is on the tenant to explain those $10,000. The burden is on the tenant to explain why in their view, we should not be counting that $10,000 as income or whatever, however that money is coming in. Was it just a lump sum? Was it a relative passed away? Was it FEMA aid for something that happened? Maybe, but that's on the tenant to explain. And if they can't explain it, they need to. And if they are not explaining it, that goes back to complying with the deed restriction and the program requirements. So the first thing I would do as the owner is you need to give these pages that are marked with blue for the tenant, give these to the tenant, have them fill it out, make sure it's complete. They've answered yes or no to everything. The tenant needs to complete this or provide a tax copy. If they're self-employed, they own a business, they need to complete the corresponding page. Same for family friend support. If they have employment, again, there's a section the employer can complete. And again, this is all fillable. The employer can complete this digitally. We accept that. We have a checklist for you, the landlord, to keep it succinct and make sure you're reviewing things in a way that will have a complete smooth recertification process, and also for submitting online. So we want you to make sure, for example, that your contact info is up to date. You have, put in your email so we can reach you if you have questions. You have reported vacant units, you have reported units with voucher holders, things of that nature. Now, the next 3 pages here are for the property manager to complete. So this would actually be step 2 or step 3, right? Step 1 is the tenant completes the checklist, yes or no, up here. Step 2, you, the landlord, get supporting documentation from the tenant verifying the checklist. And if the tenant needs to update or correct answers on the checklist, you need to get that, they need to do so. Once you have that and you're confident that the tenant's information is complete, accurate, that's when you move forward and you are now moving into these 3 pages. This is where the landlord's putting in your email, your address, the tenant's apartment number, the tenant's affordability level, the tenant's rent being charged. You would check one of these 2 boxes. The tenant is either a new tenant or a continuing tenant, and that has big implications for the maximum allowable rent for that tenant. You are only completing this page. You are only completing pages 11 through 14 once you are confident the tenant has provided not only the checklist above and the checklist is complete, but also complete supporting documentation. So to get to this point alone, if I were the landlord, I would be telling the tenant, hi tenant, please complete everything under the tenant section highlighted in blue before whatever date. And the date I would give the tenant is not May 15th, 2025. May 15th, 2025 is the date the landlord needs to submit this completed process to us at the city. So I would give an earlier date so you have time to review with the tenant and iron out any inconsistencies. All of this, if I were the landlord, would be explained to the tenant in writing so that if the tenant does not respond or the tenant refuses to complete the process and says, I didn't have to do this last year. I don't like doing this. The last property manager didn't make me do this. The landlord can say, I understand that, but I want you to understand that the AHPP program guidelines are available online. Here's a copy of the deed restriction for the building you live in, and they both require you to do this, for example. But have that in writing so that if the tenant is unresponsive or uncooperative, you can fall back and say, I did my part. I've asked you as the tenant, I've given you information. I've told you this unit's part of this program. You signed the lease addendum like Jonathan mentioned. And, if you're not going to work with us to recertify, then we need to find another tenant for this deed restricted affordable unit. Now, in terms of completeness and accuracy, landlords, you are liable if you are signing off right. So if you are the landlord and you are signing off at the bottom here, so this is where you would name the household members, right? Are they adults, minors, seniors, adult students? Are you related to the landlord? Are you a property management employee? How are you calculating the income? That's all on this page. This is to help you figure out what the household income should be. If you are signing down here on page 14, you are now liable if the tenant submitted grossly incomplete information or false information. Obviously, there's a human element to this, and I don't think anyone, myself included, could promise I will never unintentionally miss something. But that's why, like Jonathan mentioned earlier, when we notice something missing, we try to reach out in good faith at first and see how far we get with that. But when you sign, you are signing for the general accuracy of the tenant's information. Obviously, I understand if some things slip, but some things are very concerning. Like you should never ever sign down here if the tenant's bank statement shows $10,000 in deposits and you are about to sign off that you calculated up here, the page above, the tenant's annual income is $40,000 and you don't have a clear and credible explanation for the tenant as to why their bank statements show 10,000 in deposits, right? That's where you should not be signing off. Do not pass go. Just want to reiterate that. And then below here, we have the addendum. So yeah, as the landlord, you need to use due diligence and good faith review to look at tenant supplied documents. When you are looking to calculate the tenant income, do not use. So when you are calculating the tenant income, the numbers the tenant writes here, oh, I make 50 grand a year from self-employment. That number should match whatever they put, firstly, on their self-employment page, right? Secondly, on their tax return. Since this page itself is also insufficient, you need to have a copy of their tax return. If their tax return says their net income was 20,000 or 80,000, then the pages here, this page should say 20 or 80,000, and so should this form right here. It's 20 or 80. So really, in theory, there should be no discrepancy between what you are seeing as the landlord on the supporting documents and what the tenant has scribbled in or typed in on the checklist. But in the event that they are not the same number, you are using the number in the third-party document. You will be using the number, for example, for self-employment, you would be using the net income, the net profit of the business, and that's what you would be using, not the number the tenant self-declares. If the tenant has a job, you're using the pre-tax year-to-date income multiplied by the year. So if it's like May and you have like roughly 3 months of pay stubs, and it says as of March 31st, the tenant's made 10 grand this year, multiply that by 4 because it's only quarter of the year passed. And the tenant's making $40,000 based on the existing pay stubs through March 2024. That's how you calculate the income. You're relying on this third-party documentation, not on whatever the tenant puts on the form, which should match the third-party documentation. As the landlord, you are responsible for explaining deposits on the tenant bank statement. I don't personally, I'm not telling you have to personally identify, well, this $5 deposit was from tenant, bought, friend, a Slurpee at 7-Eleven. No, I'm not asking for that level of detail, but when there's like larger deposits or when there's a lot of deposits, it's actually still the tenant's responsibility. If the tenant has a bank statement that shows 20 deposits from 20 different people, maybe the tenant needs to write out a chart or an explanation. This was for this, this was for this, this was for this, but it's on them. But you need to, especially if it's a large deposit, you as a landlord need to be comfortable explaining it. Just because the tenant says, oh, that $10,000 came, it came from checking account 123, but that's not my checking account. Do you believe that? Right? Like use some, again, coming back to due diligence, maybe you ask them, can I see one page from that bank statement to confirm it's not yours? Or maybe I don't know. It's just, some of it's case by case, but do your due diligence. You're using pre-tax income for all sources of income except self-employment. That's again coming back to the importance of using pay stubs. The tenant might report their income based on what actually comes through on their paycheck after tax deductions, which is, even though these forms clearly state we are looking at pre-tax income, unless you are self-employed, then we are looking at net business income. Notably, tenants who have a lot of assets, 10% of the asset is imputed income. Once the asset combined value is $5,000. Let's say there's 3 people in a household. Person 1 has $1,000 in cash. Person 2 has $2,000 in cash. Person 3 has $3,000 in cash. Combined, those 3 adults have more than $5,000 in cash. So you are taking 10%. You're taking 10% of the combined value. That's combined value would be $6,000. You are taking 10%, $600, and you're adding that $600 to the annual income. Do not add $600 to the monthly income. It is for this page is for annual totals. Net assets include things like crypto, stocks, bonds, certificates of deposit, money market balances, a trust if the person has a revocable trust, the balance of that. If they own real estate, if they say I own a house in another state, 10% of their real estate value. They can go produce a tax document showing what the house's assessed value is. They can even produce a copy of how much money they have in the house. Let's say the house is $300,000. The tenant has $100,000 in equity. That's fine. Take 10% of that tenant equity, $100,000. And then if and when the tenant sells that house, you would factor in the sales income to the tenant's annual income. That would be separate from 10% of the asset value.
So
go ahead.
Oh, I was just gonna make a quick note about that little star there where it says it's the greater of the actual income or total value of the asset. And so there could be cases where the income earned from the asset, let's say you have a heavily mortgaged house, and they have very little equity in it, but they're renting it for $10,000 a month. Then, that $10,000 a month or $100,000 a year would need to be included in their income in place of 10% of their equity in the house, which may be negligible. So it's the greater of the actual income that they're getting as a result of that asset or 10% of that asset. Conversely, let's say they own $1 million house, they're not renting it at all, they're making no money from it. You still take 10% of that $1 million house that they own outright, and so you would add $100,000 to their income.
Thank you. In the event that you conclude items are missing from the tenant's disclosures, request the missing items in writing to the tenant and set a deadline for their return also in writing. You have the right to request additional documents. So for example, if the tenant says, oh, well, I don't know, don't count this money, this was one time, you can request additional months of statements. If you see a mortgage payment, you see, oh, it says here that you paid $2,000 to ABC Mortgage Company. Oh, well, you know what? My friend was going through a hard time. I actually paid the mortgage company on behalf of my friend. I spotted them money. No problem. Can you show me bank statements from 6 months ago? I'd like to see if there's a mortgage payment from 6 months ago. You have the right to request that as a landlord, as long as it's based on something, not just to like punish the tenant, but if it's actually based on you trying to clarify their income and you're having this back and forth with them, you're absolutely allowed to request additional information like that. Likewise, tax returns and bank statements, anything of that nature, needs to have all pages included. The tenants may not simply hand you one page and say, that's it. That's unacceptable. That doesn't work. We will not, that doesn't meet the completeness requirement. Tenants may not redact forms. They may redact maybe like all the first portion of their social security number so that it's just the last 4 digits, or I don't care, they can redact the whole thing, but they cannot be redacting, like in the bank statement, it cannot redact the address, the name, the account number, any of the line items. Oh, just redact, that's not acceptable because that defeats the purpose of reviewing the bank statement. You must include, as a landlord, you must include money that the tenant's getting through Zelle, Venmo, Cash App, etc. Unless the tenant is self-employed, in which case I would still say, hey, you're self-employed. Is that money that you're getting from Zelle and Venmo, is that related to your self-employment? And they'll probably say yes, but if they say no, you count that separately. If they say yes, you just look at the net business income as reported on their tax return, provided they have a tax return, and if not, you look at the last 12 months of statements that they again need to provide. Lastly, I want to reiterate this again. If the tenant is not providing complete, accurate information, you do not sign off and you do not complete the process with them until they provide complete, accurate information. When you are uploading forms, I know we are almost out of time here. Oh no, we have a few more minutes. When you are uploading forms, I just want to go back to this. Go to cases, occupancy reports. This is how the previous submitted recertification or annual reporting looks on our system for you as a user as well. And if you need to upload a new occupancy report for 2025, like I said, you're going to click this green button in the upper right, new occupancy report. That's how you do it. Do not go into an old one for 2024, reporting year 2022. Do not go into an old one and just upload the packet and say, I'm done, because that will confuse the system. You can see the system auto calculates like how the reporting went. It's going to confuse the system, and it will also be hard for us to locate the material as well. So if you are uploading a new report for new year, please do us all a favor, click new occupancy report instead of editing a previous year's one, which will create confusion and not give you credit for the work you completed. Moving along then, we have a point about rent increases. So we periodically, Brittany primarily gets requests from landlords to increase the deed restricted rent on rent units under deed restriction. And our practice is Brittany will actually send the landlords to me and I will review the completeness of the previous year's reporting. So that if a landlord is looking to get quick approval, the fastest way for quick approval from us for a rent increase on deed restricted units is to be up to date with complete reporting for the previous year for their deed restricted units. I just want to point that out. Questions before I move on?
I wanted to make a quick note. I think there's a note about voucher rents on there that may be out of date. Hopefully everyone at this point knows that there is no difference in the total rent for voucher holders and non-voucher holders, meaning for a voucher holder, the combined total of what's paid by the housing authority and the tenant will be the same amount that a non-voucher tenant would pay, which is going to be the amount in that chart. So I just didn't want anyone to be confused by that note in the example that was on the screen.
Thank you. Okay. We are going to briefly go through calculating maximum allowable income. So let's say that the unit is for a building that has a deed restriction dating from approximately, let's say, 1988 to 2013. In that case, you're using this middle cell for the screen, the tables on the screen are figures reflecting a building with a deed restriction signed sometime between 1988 and 2013. So if it's a new tenant, the tenant can earn up to whatever figures in this table. So for this example, let's say that the unit is a very low income 50% unit. The tenant, if it's a one-person household, can earn up to $53,000 in 2024, or as of April 1, 2025, they can demonstrate their income is up to $53,000 a year, and you can go ahead and lease them a very low 50% unit to a one-person household. Of course, the household should be sized appropriately for the rental unit. So that's why we would not be leasing a one-person household into a 3-bedroom unit, 50% apartment. Now, for continuing tenants, we understand people's income goes up and down over time. There's cyclical employment patterns and all sorts of things. And so this whatever number applies to your recurring continuing tenant households who've already lived in the unit for over 12 months, that number is multiplied by 1.4. So let's say we have an 8-person household in a very low income unit. If this is an 8-person household applying for a vacant unit, they can earn up to $100,000 a year as of now. If they are already living in the unit, they moved in 2011. Instead of 100,000, they can make up to 140. It's 100,000 times 1.4. Let me put it a different way. Let's say that the tenant's household combined makes 105,000. If they are applying for a vacant unit, they are over income for a 50% unit. Maybe they could apply for a 60% unit. They would qualify. But for a vacant 50% unit, they do not qualify. They are over income. However, if they're already in the 50% unit, we don't want them to just end up a little bit over and have to vacate. So up to 140,000, up to 1.4 times the amount in this table will be just fine to keep them in the unit. If they are over 1.4 times the income, that's when you would issue a 12-month notice to vacate the unit. And so please keep a copy of that if that circumstance does arise. Questions on that? I will add one more thing. We have just talked about what happens if the tenant is over income. If the tenant is engaging with you in good faith, they are complying with deed restriction requirements, and the only thing that happened was now the household is 8 persons making 150 grand, so they're now above 140% max for this hypothetical. Again, you would issue a 12-month notice. However, if you are instead pulling teeth and the tenant has been violating provisions in the lease, violating provisions in the deed restriction, that might open the door to a faster departure from the unit. Likewise, if the landlord leases the unit to someone over income, the landlord could be in trouble. If the landlord leases a 50% unit to a household that makes $110,000, $140,000, $180,000, the landlord may end up removing the tenant from that unit because it has to go to an income qualifying household at move-in. It cannot be rented to it cannot be rented to an 8-person household making over 100 grand. And that family that was wrongfully admitted to the unit, the landlord may be responsible for relocating and paying the relocation. This could include utility connection costs, moving, packing, unpacking, and so forth. I just want to point that out. That is an incentive for landlords not to lease deed restricted units to people who are over income. My last note here, if someone is in a deed restricted unit and they want to move to a different deed restricted unit in the same building, that may still establish a new tenancy. So as a landlord, it comes back to your record keeping. You're going to want to keep a good record. And if the tenant has started a new tenancy, a new lease, make sure you have a copy of it. And again, you would also still be notifying the city that, the household composition for unit X has changed. That tenant moved to unit Y. You would notify us of a vacant unit. A couple final points. Gifts and loans. So tenants may describe the Zelle Cash App Venmo money that you see on their tax return as coming from family and friends. Oh, it's, I loaned them money last year, so they're paying me back. That's fine. You would take an average of that over multiple months and you still count that as income unless the loan was notarized at the time it began. So if the tenant can say, yes, look, I had a personal loan. We're not talking about loans from banks here, but a personal loan from a friend or a family member. Hey, can you spot me money? If they went and got it notarized at the time this all began, no problem. We won't count that as income. Otherwise, it does count. But you can average it across multiple months. We've talked about income for self-employed tenants and tenants who own part or all of a business. There are some complications there where some tenants may use accounting maneuvers to in terms of determining their income. So if you come across one of those where a tenant seems to be high income but is using accounting maneuvers to show themselves as low income, please let us know and we will work proactively with you. And lastly, oh, no, that's all. So we have here some examples. And I just want to go through these in our final minutes. And I also welcome questions. I know it's almost 2, so you have to go, please do, but you can leave questions in the chat. We will respond to you if you need to go. Otherwise, we're almost done. We have one example. Tenant declares 1,000 in the bank account. Their most recent bank statement shows 3,000. How should the landlord proceed? Anybody want to suggest? Okay. The landlord should use the 3. Go ahead.
Linda says, ask for 2 more statements and use the average.
The tenant did not provide a statement, or they should have, but you would use the amount in the statement. You can absolutely use an average. That's fine too. But you are using the amount on the statement, not what the tenant declares. And you would ask the tenant, please update what you put on the form to show the fact that on the statement you provided, it shows 3,000, or the average is in fact 2,000. So please put 2,000 on your tenant declaration. Thank you, Linda. Example 2. The bank statement shows the tenant's paying themselves $1,000 a month. And the tenant says, I have no additional bank accounts. What does the landlord do? Any suggestions? I would suggest the landlord, the tenant cannot, the way Zelle functions, the tenant is not just uploading dollar bills to an ATM somewhere and it ends up in Zelle. So the tenant's explanation in this case would not make sense. And the landlord should not accept the tenant's explanation until the tenant can accurately clarify where the money's coming from, because it's not just cash being uploaded to Zelle. It has to come from maybe Cash App, Venmo, maybe not a traditional bank account, like Venmo or Cash App are not traditional banking institutions, but it's coming from somewhere. So that's not a answer that passes the sniff test. We have 2 more what if situations here, but I would actually open the floor to landlord questions since I know we are at time. You are also welcome to contact us with questions upon reviewing this. Go ahead. Okay. You're welcome to contact us if you have any more questions about this. I really appreciate your time today, and thank you for your cooperation with ensuring the program works efficiently for all of us. So thank you for your time. Please reach out with questions. Take
Hey,
care.
Nicholas, can I
Yes.
get a quick question?
Yes.
If we're a little bit behind and we need to do our 2024 recertifications as well as our 2025, do we need to get like bank statements and all of that from, let's say, December, November, October of 2020 2024 as well as like 2025 bank statements?
Yeah.
Okay, perfect. Sounds good.
Yeah.
Appreciate
Thank
it.
you. Mhm. I'll stick around for a few more minutes, but I'll stop recording. So thank you again, everybody.